Everyone, thank you so much for coming in or coming out or tuning into this session, the third session of Founder University Education Series. We're very excited to have everyone here, and we're also excited to have our speaker, Kevin Everage, here to talk about IP and choosing the right business entity. Kevin is an associate at Dickinson and White and Wright's Las Vegas office, and he's focused his practice on intellectual property with an emphasis on litigation and patent prosecution. Kevin sharpened his IP skills in his prior roles as a patent agent and intellectual property coordinator with the Las Vegas-based designer and an operator of a highly rated data center and highly rated data center ecosystems, and as a patent examiner for the United States Patent Office. He's been regularly involved in helping various business owners take care of their IP business entities. He's worked with a lot of entrepreneurs as well, and he's a big advocate for this ecosystem. So without much further ado, Kevin, please round out anything else I left out there, but please take it away. We're really excited for hearing from you, but thanks for joining us.
I appreciate the intro. One other thing I would add is that I came up through Las Vegas's public school system. I graduated from UNLV. I've got a lot of ties to this community. My family's lived here since 1997. So it's a pleasure for me to be here and to talk to all of you. So let's get right to it. The first of the topics I'm going to be discussing is actually intellectual property. I feel like having a background discussion about the basics of what it is, how it's created, how it's protected, how it's enforced will better lead into the discussion about forming the right entity for you. So I'll begin there. So just a quick overview of the intellectual property rights that are available to individuals and to businesses. You're probably already very familiar with these topics. We'll get into a little bit of the details. The first one, this is my expertise, is patents. Patents protect devices, methods, the visual design of a physical device or a broadcast of a certain image from, say, a program, and actually plants. And plant patents are something that are starting to get more traction. Historically, haven't been very active, but with the rise of cannabis and the loosening of restrictions we're starting to see a lot more applications and registrations of plant patents. The different types of patents that are available are, first, there are provisional patents. A provisional patent is basically just a placeholder in line for you, just to try to get your foot in the door with the patent office, to disclose your idea and essentially reserve your rights to that idea set on that date that you file the provisional. The requirements for a provisional application are minimal compared to a non-provisional. And because we are now, as of 2013, a first to file country, more in line with how the rest of the world works, the name of the game is getting your patent idea on file with the USPTO as soon as possible. And so the provisional path is a way for you to kind of reserve your rights while still buying you some time to decide, maybe I don't really want to pursue this idea all the way through. Maybe I want to look and see if there's a need for me to get more investment before I proceed. Maybe I just kind of want to do more research about whether or not this is even patentable before I spend the money that's necessary to file a non-provisional patent and then see it through the application to registration process. A provisional application is generally cheap. I think the fee structure at the USPTO is based on what your status is as either a business or an entity. They have a 3-tiered fee table that it comprises just the regular fee. There are small business fees, and then what they refer to as micro entity fees. The micro entity fee is very advantageous for individuals and very small businesses that will save you, I think, up to 75% on all the fees that the USPTO charges related to patents. So the non-provisional patent is a path that is available to someone that is committed to getting an issued patent for their idea. You can start with a provisional patent and then have up to a year to convert that into a non-provisional, or you can just go straight to the non-provisional path. So the non-provisional patent application will disclose your idea. You'll have figures, a detailed description of the idea, the invention, and claims that break down what it is that you're defining your invention to be. The claims are probably the most critical aspect of the application. That's the part that you're going to see the most back and forth with from the USPTO examiners, that will essentially define your rights to your idea when it eventually, hopefully, gets issued. It is preferable to have very broad claims related to your idea. The broader, generally, the better. And the broader they are, the more likely you are to have a larger scope of protection if and when you start to see competitors come into your field and try to compete against you with an idea that's very similar to your own. So quick overview, trademarks. Trademarks are a type of intellectual property that is intended to protect brand names, product names, logos, product imagery, which I probably intended to say that this was trade dress, which is a type of trademark that is related to certain source identifiers of your business that are visual. It could be a shape or a color, and collectively, all of these trademarks are what are known as source identifiers. The rights to a trademark are based in your ability to use this name, this logo, this shape, this image to create a connection between the consuming public and your business, so that once they see that name, that logo, that product, they immediately associate that to you and your business. You are the source of that is universally recognized. The strongest brands take they use a lot of resources, money, marketing, development to create awareness among the consuming public about who they are, what products are coming from them. And once they have that recognition, they are then able to go enforce those rights against other competitors that try to enter the same field and essentially compete against you using your name. Copyrights are a type of intellectual property that protect original works of authorship. And I think a lot of people that practice in intellectual property, I hear a lot that patents are the toughest, they're the hardest to understand. And I think a lot of that stems from the fact that they have their own bar exam at the USPTO that practitioners need to pass if they want to represent others in applying for and receiving a patent, or during an appeal or an IPR. But in my opinion, copyrights are the toughest there is. Copyrights get down to a lot of very nitty-gritty details of what the work of authorship is. And there are a lot of exceptions that apply to whether or not something that's similar is infringing. Trade secrets, I like to use the phrase secret sauce, because that's really what a trade secret is. It's a secret. It's something that will protect the way you go about doing your business that's unique to others, that you have, I guess, identified a way to make a process more efficient, or maybe you have generated certain proprietary data that if others knew about would give them an advantage that you currently enjoy on your own. Trade secrets are generally protected through a process of putting in certain procedures within your organization to maintain the secrecy and to also contractually bound individuals both internally and externally outside of the business that you partner with or that you use as vendors to ensure that they have certain non-disclosure or confidentiality obligations to you before you disclose to them what your trade secret is. The last type of intellectual property that we're going to discuss a little bit are rights of publicity. These are vested in individuals. It's essentially boils down to your name, your image, your likeness. The acronym for that is NIL. That is something that is being discussed a lot more in the media, particularly in the sports media, as the NCAA has recently revised their rules on payment for amateur athletes to allow them to generate revenue based on their right to publicity. So jumping a little more into patents, I already kind of described what a provisional application is. It's a placeholder for your idea. It buys you time up to a year. And that year is the 1 year time period is something that's very important because the number one issue that I see businesses or entrepreneurs running into when they have an idea that is potentially patentable is that they don't understand that from the moment you publicly disclose your invention or the first time you sell it, you have now triggered a 1 year time period in which if you do not file an application for your idea, that year passes, that idea is now public domain. You have forever relinquished your right to obtain patent protection for that idea. So oftentimes I'll have people come to me, they'll say, hey, I've got this idea, this invention that I created that I made years ago, and it's really starting to take off. I'm making a lot of good money now, and I want to make sure that nobody else starts to sell this too. And so the first question I have is, well, when did you first publicly disclose it, or when did you first start selling this? And they're like, well, I really started getting a lot of traction about 2 years ago. Conversation's over. There are certain ways that you can potentially get a patent if you've made this error, but it would essentially require you to make advancements upon the invention that you already created that are new and non-obvious from the invention that you already have. And once you get through the application process, they'll issue you a patent. It'll have a patent number. Currently, they're in the 11 millions. The patent game is getting really hot right now, especially as well as with trademarks, particularly because of COVID. A lot of people were stuck at home and a lot of people were out of work. And so naturally, everybody needs to take care of their families. People started generating, oh, how can I get my own small business going? What kind of ideas do I have that can potentially lead to something that I'll have more control over myself? And so we saw a lot of filings in the patent and trademark space during the last 3 years. And it's only continuing to grow. I already kind of covered this key issue. When was the invention or the idea first sold or published? You definitely want to always keep that in mind because, again, that triggers a 1 year time frame for you to initiate the process of securing patent rights with a registration for the USPTO. And the USPTO in the United States is the only source of patent rights. This isn't something that you can satisfy on the state level. You have to go through the federal government, through the USPTO and their process. It is wise to retain legal counsel for this process. They release statistics from time to time. I think a number that I hear very often is in the 90% range, that 90% of patent applicants that file and try to navigate the process on their own are unsuccessful. It's not to say that's, yes. Searches will save you a lot of time and money. Searches are something that you can do yourself. There's something that you can pay a law firm to do. There are entities that their entire business is doing patent searches for others. You can Google these, and I'm sure you'll have plenty of options pop up, and they'll be happy to give you their pay structure to let you know about how much time and money it'll cost. For a patentability search, I think that it's common to see price quotes in the range between $500 and $2,000. Kind of depends on the area of your invention and the depth of the search that you want performed. The reason why a search can save you time and money is because just a lot of people have a great idea, but to get a patent, your idea has to be new and also non-obvious. And when I say new, I mean that it has to have not existed or been published essentially worldwide before you file for your patent. And so you would be doing yourself a favor in many instances to do a search both of existing patent applications, issued patents, as well as non-patent literature, to make sure that you feel comfortable that this idea you have is either not out there or significantly different from the things that are out there. If you find something substantially similar, you might want to just get back to the drawing board, do something else, or maybe you identify a way to build upon an invention that's out there. You can often get a patent on an advancement on existing technology. It's just that advancement has to be, again, new, non-obvious, and useful. So well, here's somewhat of a timeline. I think these were intended to be arrows of the process. You have the idea. That should trigger whether or not you want to perform a search. After you do the search, if you feel comfortable, you apply. And then at that point, I would say start using, although, again, you can start using the idea, start selling it, start disclosing it to others. But just be cognizant, though, that the minute that you do, you have up to a year to get that application in. One effect of filing an application is that at a certain point during the process, the USPTO will publish your application. You can elect to have it not published, but most people elect to have it published. And that is one way to put the world on notice of the fact that you are claiming rights to this idea, even if they haven't yet vested with a registration. Once you do have the registered patent, you will want to start marking your products in a way that indicates to others that this is a registered patent. You want to include the registration number. During the application process, it's not uncommon for people to put markings like patent pending to try to, generate awareness that we're claiming rights in this invention. It may prompt them to do a search to make a preliminary decision about how similar your application is to an idea that they might be already selling or deciding to sell. Once you receive your patent, you'll want to typically enforce it through cease and desist letters once you identify technology that you think is infringing on your idea. That cease and desist letter is another way of putting them on notice that they're infringing. And depending on the target and their resources, it may it may bring them to the table to either just stop entirely, which is what you want, or they may approach you about potentially licensing your idea and your patent. And so now you're generating income, or they may want to just settle out with you entirely and close up shop to make sure that you don't come after them and they have to spend a ton of money defending themselves in court. For people that are resistant to your cease and desists, infringement lawsuits are the typical way to go about enforcing your patents. These can be very, very expensive. You will want to do a little bit of homework. You want to talk with your counsel that you retain prior to initiating the lawsuit about expectations and timeframes. But a successful infringement lawsuit may entitle you to a reasonable royalty based on past sales from the other infringing parties or for lost profits. Patents last 20 years from the date that you file them, which is a little unfortunate because the application process can take a long while. And so say it takes 2-3 years, sometimes they may adjust your patent life to give you back some of that time. But in general, say you receive your patent 3 years after you filed for it, it's only going to be enforceable for 17 years after that. For design patents, which protect the visual aspect of your inventions, those are entitled to 15 years from when they are granted. So you at least know with a design patent, you're getting a solid 15 years of protection. So trademarks exist both as registered marks and common law marks. A registered mark is a mark that's been presented and disclosed, applied for at the USPTO, and the USPTO will issue you a certificate that gives you a registration number, that defines the scope of your use, the goods and services that you use that mark for, and the date when you first used it and when it was registered. Common law rights are unregistered rights with the USPTO. They are still enforceable. However, they are only enforceable on a much more limited scope. So for instance, say you have a business selling fruit and you name this business Chairs. I'm just obviously making things up that are in front of me. So your Chairs business sells fruit. You get a registered trademark for Chairs, and you come across, or sorry, we're talking about common law rights. You don't register your rights in the business and you operate just in the state of Nevada. If somebody starts using that name to sell the same products, fruit, in, let's say, New York, because your rights are not registered, they're common law rights, you're only allowed to protect those rights typically in the geographic area where you practice. So those common law rights may only be enforceable in the states in which you operate. In this case, in the example, only in Nevada. If you pursue a registration and are successful, you can enforce those rights throughout the United States. There's a couple different types of trademarks, but they're generally the same in effect. Trademarks and service marks are equivalent. It's just that a trademark is generally for a product, while a service mark is related to a business that performs a service, say like a plumber. You can have your plumbing business and not sell any goods, but your business will have a name, and you will want to have any goodwill that's generated in your excellent plumbing service when you come out to someone's home, fix their leaky pipes. They're very satisfied with your process, your demeanor, your prices. They refer you to their friends. Now you're generating goodwill in your business. You want that name associated with that goodwill to all source back to you. You don't want somebody else to perform the same service under that mark. Trademarks can also be divided in categories like word marks and design marks. A word mark is obviously just a word or a slogan something that generally just uses words. A design mark is a logo. When you file to register a trademark at the USPTO, you can take one of two paths at the beginning. You can either try to essentially reserve rights in an idea that you have a bona fide intent to use for a mark, but during the process, at some point, you will have to convert that into an in-use application, because trademarks are created and kept through actual use in commerce. You can't just own a word and enforce it against others that might be using it unless you are actually using it for business purposes and for a specific category of goods and services. To the right here, you can see some of the symbols that indicate a word or design might be protected by somebody else, or you might want to use on your own. The TM symbol is for generally unregistered marks, but they might be for registered marks. You can use that one interchangeably. A service mark is the same, except for services, and the registered R, the R with a circle, is an indicator that a mark is registered. Some entrepreneurs, when they're getting started, don't understand that. They think that they should put that logo next to their business name or their business logo so that other people will know, hey, this is mine. But that is only supposed to be used for a mark that has gone through the registration process and been granted a registration. There can be penalties if you misuse it, but typically they can often be excused for various reasons. Again, we mentioned that trademarks vest in words and logos that are used in commerce. And if you were to enter into a dispute with somebody over rights in a trademark, the key issue is going to be, well, who is the first to use it in commerce, typically. Like patents, searches can save you a ton of time and money. I cannot tell you how many times we've worked with businesses that fall in love with the business name and they just go full steam ahead, and then some point down the line they get one of those cease and desist letters, and a common reaction is to just dig their heels in and say, no, this is mine. I've been spending a lot of time, money, and effort in developing this business. I don't think I should have to change. You really kind of want to get some legal advice in these situations, because if you were not the first to use it in commerce for similar goods and services in particular, you might be exposing yourself to some pretty heavy liabilities. So when you're in the early process of defining what your business's name and logos are going to be, it is very critical that you either perform a search of your own or hire a professional to do a search for you to give you a sense of what liabilities are out there if you decide to move forward with that name. Like the patent process, again, the idea for the name should trigger you to perform some amount of searching. After that, it is recommended that you apply to register that mark so you can get the broader scope of protection. And then at some point, or even during the process, start using it. Because again, trademarks vest in use, and you want to be the first to use it in commerce. Just make sure that you are the first to use it in commerce. These are often enforced the same as patents with cease and desist letters. If those are unsuccessful, or if you are the target of a cease and desist letter and you do not comply, that might trigger an infringement lawsuit, which again can be very expensive or lucrative depending on which side you're on. At the same time, you don't want to be the one that's filing an infringement lawsuit in the first place, because while you may be made whole in some regard from damages that you recover, in the meantime, that other person or entity's use of a trademark that's confusingly similar to yours, is damaging your brand, particularly if they're performing in the same field as you, but not performing up to the same standard that your customers have come to expect from you. Trademarks last for only as long as you use them. If you discontinue use of your mark for about 2 to 3 years, you are subject to losing your rights in your trademark. So continuous use of a trademark is essential to maintaining those rights over time. Whereas a patent will expire after 20 years from the date of filing, a trademark can last forever. Copyrights exist like trademarks as either unregistered or registered. If you want to enforce a trademark or a copyright in a lawsuit, you will first have to go through the registration process. The different kinds of works of art that are subject to copyright protection include literary works, musical works, dramatic works, everything that you see listed here, and derivatives of the same. The key phrase, fixed in a tangible medium of expression, is the phrase that is used to describe how a copyright is created. A copyright is created the moment the work of art is fixed in a tangible medium of expression, as long as it is an original work of art. What that means to be fixed in a tangible medium of expression, each of these terms is legal jargon that has been litigated and beat up over many years, but suffice to say that let's say that I make a drawing. That drawing is on a piece of paper. A piece of paper is a tangible medium of expression. If that drawing that I created is original, then the moment I created it, copyright is vested in that. Whether or not you choose to register a copyright for that is entirely up to you and may be dependent on whether or not like you're in the business of trading art or publishing your art and want to be able to quickly enforce that right if somebody is going to infringe those rights. I'm going to just take a step back for a second to mention that when I say that something's fixed in a tangible medium of expression, that right vests immediately by the person that does it. So something that happens a lot when people are, say, on a vacation is they will, someone will take a picture of them and they'll want a copy of that picture because they like the way that it looks. Well, just because they shared that with you and it's you in the photo doesn't mean that you own the copyright. They own the copyright because they were the one that took the picture. They're the one that fixed it in tangible medium. And it's very important to recognize this, especially as your business is growing, because again, a lot of these rights that you're going to want to vest in your company are going to have to be protected through contractual means. So you want to beware joint authorship and works made for hire, because these are processes that a lot of people don't really understand what they are and how they work. A joint authorship can be created unknowingly. Say you and a friend are both musical artists and together you decide to create a song and you're doing it in your basement. If you are both contributing substantially to the song, whether it be the music that underscores the song or the lyrics that are performed over it, if you are working in concert with each other, the end result is that each of you is a joint author of that work, unless you had some agreement before it was created to make a decision on who owns what. And once you become a joint author, each of you has the right to essentially sell this, license this work that you've created together. The only limitation is that whatever you're generating from it has to be shared with the joint author. So say myself and someone else create a song together. I license it out and generate $1 million. I owe 500 grand to my joint author, but they can't stop me from entering into these deals and I can't stop them from entering into these deals. So you definitely want to make sure that before you're working with others in an area of practice that's generating copyrights, you have agreements in place that define who owns the works that are being created. And one way to do that is to have a work made for hire clause and also an assignment agreement built into any contracts that are being executed between you. A work made for hire clause allows you to retain the copyright in something that's going to be created by somebody else. And there's specific verbiage that needs to be included in that agreement to make sure that this right vests back to you. There's a very common practice for larger businesses to bake into their employment agreements. If you are paying close attention to the terms of your employment agreement as an employee, you may see assignment clauses and work made for hire clauses that essentially lay out that any work that you create on the job using company resources during company time within the scope of your duties, those rights are either works for hire as a copyright that vests to the company, or say it is if you're a graphic artist, a logo, a trademark, or if you're an inventor, an engineer, something that's subject to patent rights, anything that you're creating automatically becomes owned by the company as a result of you entering into that contract. So as a potential business owner yourself, you're also going to want to have these kind of contracts available to you to have signed by your employees, by your independent contractors, anybody that's going to be performing services for you that is going to generate intellectual property rights that you want vested back to you or your business. I feel like I'm getting a little behind, so I'm going to start speeding through some of these. This slide just generally lays out, well, the key takeaway here is that for works created after January 1st, 1978, that's the current rule. Copyright protection lasts for the lifetime of the author plus 70 years, or if it's a work made for hire, 95 years from the year of its first publication, or 120 years from when it was created, whichever expires first. The great thing about registered copyrights is that there are statutory damages for infringement of registered copyrights, which is a fantastic source of making you whole in the case somebody infringes your rights. Trade secrets, as we kind of sort of glossed over before, is information that includes formulas, patterns, compilations, techniques, processes. This is common in the food industry, the pharmaceutical industry, where they have a secret recipe. I use this example a lot, the Coke formula, which is something that has existed for a very long time and is exclusive to Coca-Cola. I believe they have protected this formula as a trade secret for a very long time, rather than trying to say patent the formula, which would require them to disclose it to the world. And then upon the expiration 20 years later, allows anybody else to make and sell that product. By maintaining something as a trade secret, it can last forever as long as you have processes in place that meet the standards under state law or the Federal Defend Trade Secrets Act to ensure that you are maintaining proper steps and efforts to protect your trade secret. It doesn't necessarily have to stay a secret. If that secret is later disclosed by somebody that was bound to keep the secret to you, you can still maintain that secret going forward and recover for any damages that were created by that bad actor disclosing your trade secret. Again, trade secrets are protected through contractual means, typically like NDAs, confidentiality agreements, but also through reasonable efforts by you to maintain that secret vested within your business and those who are in the need to know. This is something that you're going to want to have ready as an agreement to be signed by, say, certain vendors or manufacturers. Say you have a product that requires bottling, and they're going to need to know the process of creating it and then bottling it for you. Well, now you've told them your trade secret of creating my secret formula. Well, if you did not have this agreement in place before they started performing these services for you, you may have just given up your trade secret rights. I'm just going to gloss right past rights publicity. I just wanted to flag this for the audience that this is becoming a more popular issue, particularly among high school athletes that are entering college. A lot of colleges for their athletes have name, image, and likeness groups that will invest in their athletes to come to those schools, offer them money in exchange for certain basic obligations like appearances in certain locations, to sign autographs, or to create social media posts. This is a major shift in the NCAA that I don't think we've heard the last of. Because it's so new, there's probably going to be some more shifting in the near future. So choosing the right entity for you. Just a quick overview of some of the known types of business entities. There are sole proprietorships. Sole proprietorship is just essentially you as an individual. Say I mentioned plumbing before earlier, so I'll go back to that. If I have the skills and the certifications to be a plumber, and I just decide one day I'm going to go out on my own and start doing this. If I don't create a business entity and I'm performing these services as a business, I am a sole proprietor. A partnership is similar to a sole proprietorship. It triggers through action, but it is that action with you and one or more others that are working in concert to perform those services. A limited liability company, these are probably the most common business structure for growing small businesses that don't really have many investors or members. And then you have corporations which vary in size dramatically. You can have a corporation with one individual, or you can have a corporation with many, many individuals. But typically a corporation will still need to have some sort of board of directors and are a lot more complicated in terms of setting up and dividing rights and laying out the foundation for control. So sole proprietorship is something that does not have to be registered. It can be registered, but you can create one essentially just by doing a job. This can be dangerous because as a sole proprietor, if you're performing business services, you have unlimited risk in the event that you cause harm or damage to somebody else. Back to the plumber example, I go to someone's house to fix a leaky faucet. I make a mistake and I yank on something too hard, and now there's a pipe leaking and it floods the entire bottom floor of the house, and then it soaks down into the foundation, and there's 3 feet of water rising, and the house is completely messed up. There's tens of thousands of dollars in damage that needs to be repaired. As a sole proprietor, you and all of your personal assets are at risk, which means everything you own may come into play if you become sued for the act that you did that caused this damage to somebody in the course of action of performing a business as a sole proprietor. So say you cause $1 million in damages, they can come for you, all your bank accounts, all your investments, potentially your home. There are ways to try to get around that through the bankruptcy process, but just to know generally, if you're acting your business as a sole proprietor, you are at unlimited risk for any damage that you cause. Also, as a sole proprietor, there's no real tax flexibility for you. All your income gets reported on your personal income tax statements, and you will be taxed according to the income rate table. For a general partnership, these may also not be registered, and they can be created informally just by saying, hey, me and my partner here are entering into business. You can come to us for these services. You can reach us here. If you're representing yourself as a partner to somebody and you're sharing tasks of the business, you may have entered into a general partnership. This is similar to a sole proprietorship in terms of risk, But now instead of it being vested in just one person, it's shared amongst all the partners. And so the actions of one person can be recoverable from another person in that partnership. So again, I start a business with a friend. We don't really know the rules of this, and we unwittingly create a general partnership. I make a huge mistake. Our partnership gets sued for $1 million. I've got $10,000 to my name. My buddy's got a whole lot more money than me. They can come after my money, and if everything that I have does not cover it, they can come to my partner's money too. So again, you're taking on a lot of risk by operating a business as either a sole proprietor or a general partnership. And again, there's no tax flexibility here. However, there's an entity type called a limited liability partnership, which you can register with the state, which will create some liability protection for you in the form of protecting your personal assets. These are a bit similar to LLCs, which we'll get to in a minute. So LLC, this is the most common one that you see among small businesses. You register these through the Secretary of State. You can register a business in any state. It doesn't have to be the state that you're headquartered in. A lot of businesses are registered in the state of Delaware simply because that state is very friendly to businesses and has preferable general terms for their default agreement, their default operating agreement. Nevada is another one. To register an LLC, you go to the Secretary of State's website. Here in Nevada, it is nvsos.gov. There are tabs at the top that should guide you to where you need to be. Or if you don't want to do this yourself or don't feel comfortable doing it yourself, you can hire an attorney to do it for you. Upon registration, your business will have to file its articles of incorporation, naming the owners, the address, all the necessary information about the company, and you will be given a tax ID number for tax tracking purposes. LLCs will protect your personal assets. There's no personal liability or liability for actions of the other members. There's some amount of tax flexibility, and the rules of the company are governed by an operating agreement, which supersedes the default rules of the state you're incorporated in. However, if you create an LLC, as say a single member LLC, I want to create a business just for myself. You don't want to go through the trouble of an operating agreement. You want to just make sure what the default rules are in the state you're incorporating in. But if you do decide later to grow, expand, add new members, you can always revise or create a new operating agreement later. It's a lot simpler in that case where it's a single member LLC, because you as the only member have the control over whether or not you want to change the terms of the operating agreement. So ownership in an LLC is divided among what are called members. And it is controlled by a manager, a group of managers, or the members themselves. Corporations are a more advanced form of business entity that is also registered through the Secretary of State. You can see if you see a term like corporation, incorporated, corp, or inc., those suffixes are typically indicative of a business type that is a corporation. I'm going to jump back for a second to point out that if you see a business name that has the suffix limited liability company, limited, LTD, LLC, with periods or without, or LC, these are all suffixes that will indicate to you that that business is a limited liability company. There are a couple of different types of corporations. Two of those are C Corps or S Corps. They have slightly different tax rules and rules of operation that accompany those. It is a conversation you should have with representation if you're going to decide which one is more appropriate for your business. In a corporation, ownership is divided among what are called shareholders. and collectively the shareholders will elect a board of directors that makes all the major business decisions for the company, and then kind of gives guidance to its officers, its C-suite, its CEO, its CFO, its chief information officer, and has the ability to hire employees in those roles. Payment from a corporation is typically through dividends and distributions, which can be taxed at a more favorable scale, particularly if you are a higher income individual. Corporations can exist as either a public corporation, which will require you to register with the SEC, and you will then want to be registered on a stock exchange so that the public can trade your stock, or you can have a corporation that exists entirely privately. It's simply registered with the state and designates who the board and the shareholders are, and operates many ways like an LLC, but according to the specific rules that exist for corporations. We only have a little bit of time left. I apologize that I kind of blasted through the business entity formation stuff at the end there. It's just that I think that once you have an understanding of what intellectual property rights are, what you do as a business and the kind of protections that you think are necessary for you should guide you to creating the type of entity that you need. And once you create that entity, you're going to want to have the necessary contracts in place and ready for others to sign to make sure that all those intellectual property rights vest back into your business. So with that said, any questions?
Excellent. Thank you so much, Kevin. That was really informative. And we do have a couple of questions online, and we have a question here in the room.
The question that was posed was, if a business has something that it's doing that is potentially patentable, but they haven't sold it, they haven't published it to the world, how does that affect their patent rights? So the answer to that, it kind of depends on what steps you've taken to maintain the secrecy, and I guess it also kind of depends on how you say you're using it. If you're not selling it, is it a service that you are acting? It's a process. Well, if that process is necessary to something that is being sold, then it kind of depends on whether or not that process is itself a service that people can see you performing, or if it sounds to me more like this is something that is a trade secret. And so you can kind of maintain your rights in that as a trade secret, put all the necessary measures in place. And if you have kept that idea, that process a secret, that is not published, that is not sold per se, somewhere down the line, you may actually make a decision to say, all right, now I do want to patent this, and you can patent it later. But the moment you decide to do that and you publish it, now you're essentially giving up any opportunity that you had to maintain that as a trade secret forever.
Excellent, thank you. Cara, the online audience, you want me to go ahead and just read off the question that we have from online?
Yeah, perfect.
All right. From David online, if you send a cease and desist letter accusing infringement and the offending party keeps infringing and you do not sue, do you automatically lose your patent?
Well, no, you don't lose the patent, but there's a concept called latches, which essentially means that if you are aware that somebody's infringing, and you have now proven that you're aware because you sent them a cease and desist letter and you've accused them of infringement, and then you allow them to keep on infringing for some amount of time, let's say a year, 2 years, 3 years, like the more time that passes, the more likely it is that you're no longer allowed to sue that infringer. So the concept of latches can come into play, particularly with that infringer. It doesn't necessarily mean that you've given up your right to enforce your patent against others that may pop up later, or ones that you're not aware of. So if the difference between the marks is simply a dash between the words, I would say that you only need one or the other, because if somebody else was to use the one that you don't have, the test for trademark infringement is whether or not there's a likelihood of confusion. And so say you are selling soft drinks and you have a registered trademark for Coca-Cola. Someone else wants to sell soft drinks for Coca-Cola, no dash. The likelihood of confusion between the two is readily apparent because they're substantially similar, particularly if they're the same font. But that one dash in between, not likely to change the likelihood of confusion test, particularly if they're using the mark for the exact same services that you are.
Excellent. I think likelihood of confusion, that's a really excellent point. From online, from Lenny, my business creates art for other business to advertise on my website. I also use their artwork, their logs with a simple MOU agreement. Am I at risk?
I'm sorry if I don't answer this question entirely accurately because I can't necessarily understand it entirely, but from what I understand, you are creating art that others are then using as logos. So this is something that will depend on contractual agreements between you. If they are hiring you and paying you to create the logo, and you have a contract that memorializes that service, then if in that contract there is an assignment agreement or a work for hire clause, then the work that you're doing will vest the intellectual property rights that result in it back to them. And this is going to be particularly important for any potential copyrights in what you're creating. Copyrights that apply to logos will often depend on how original the work of art is. If it's a simple logo, there might not be any protectable copyrights in it. But as we talked about before, trademark rights vest in use. So just by creating that logo, you don't vest any trademark rights in it. The trademark rights will probably vest in them when they then take it and then start using it as a source identifier for their business. But the copyright issue is something that's largely dependent on the complexity of the art and the agreements between you and the person that is paying you to create the logo.
Lenny, if there's additional information that can bring that to bear, feel free to put that in the chat and I'll swing back to it. Kevin, actually, I got a question. So say that a founder it has technology and they file IP on that technology, but they reserve either additional developments or certain, call it secrets or information from the patent filing in an attempt to, you know, they make maybe they're afraid that it's going to be copied even though they do have a patent or whatever have you. Mm-hmm. Have you seen that? And is that common? Is it legal, etc.?
It's not uncommon and it is legal. It's when you file for a patent, you need to disclose in detail what it is, how it works, and the best mode of implementing the idea. And so if there are certain aspects of it that aren't necessary for someone else to then, from your application disclosures, then make and create the same device, then you can reserve those extra secrets to yourself and maintain that part of it as a trade secret. But if those things are integral to what you're trying to protect as a patent, those parts would have to probably be disclosed within the patent. So it kind of depends on what these trade secret elements are and how they interrelate to the patentable material.
Gotcha.
But in general, yes, you can have trade secrets that support a patent.
Gotcha. But if it's pertinent, directly pertinent to the development and the best practical application has to be disclosed in the patent, essentially, generally.
Generally, yes, because with a patent, you're essentially disclosing your idea to the world to the point that once the patent expires, anybody should be able to read your patent and then now make it and use it themselves.
Yeah.
It should now enter the public domain. And so if there's a part of the patent that you have withheld that now they can't then recreate this invention because you've held
Then you
that
don't have a
back,
patent.
then if you do have a patent that is registered for some reason, it may eventually be invalidated, or it might not ever be registered in the first place if you haven't sufficiently described the invention.
Gotcha. From Kara on our team, can you discuss the international patent filing process? I know that could lean into a number of areas, but if you could keep it, streamlined general for us, that'd be excellent.
If you want to enforce your patent rights internationally, you will have to file a patent application in one of the approved offices. The United States is one of them. And then you will start a national application here, while at the same time having a PCT application number associated with your invention. And at that time, you will also designate the specific countries that you intend to file national applications in internationally. And so say I create an idea that I want to protect in the United States, that I want to protect in Canada, that I want to protect in China, and I want to protect in Japan, I will file a USPTO application and a PCT application through the USPTO. It doesn't necessarily have to be at the same time. There is a certain window that you have to file later. And then once you file the PCT application, there's another window of, I think it's about 18 months, maybe more, that you have to then start filing the national stage applications in those other countries, like the ones I mentioned, Canada, China, Japan. You don't have to then pursue later those foreign applications if you don't want to, but you do have to reserve the right to at the time that you file the PCT application.
Excellent, thank you. Then from Sujin, approximately how, on average, how much does it cost, and you can give a range, and this might vary widely, to go after an infringement for a utility patent for a method and device in the US?
Well, whether the utility patent is related to a method or a device shouldn't affect much the cost for enforcing your patent against an infringer. How much it costs depends on how much they fight back. The first step that we mentioned, it was sending them a cease and desist letter. Depending on the complexity of that, it could get a little costly, but I don't see why a cease and desist letter can't be prepared in an hour or two. And so if it's being prepared by an hourly rate from a law firm, they'll just bill you for that hourly rate, and maybe it's $300 to $1,000 to prepare and send this cease and desist letter. If the cease and desist letter is received and the message hits home, and they decide they're going to stop infringing, they give you all the assurances and the evidence that you need to feel satisfied that they're going to stop infringing, and you're okay with not pursuing them for past damages, then that's the end of it. But on the other side of that spectrum, say you're going after a very large corporation and you're the small guy, they feel like they have the advantage as far as resources, then they may decide that they're just gonna sit back and let you come after them. And if it's worth it to them, just fight you in court and take it all the way to a judge or jury decision, depending on what type of trial you've agreed to. The process can take several years. It can take depending on circumstances, anywhere from 2 to 5 years. If you're going to be involved in a 5-year patent litigation, you could be expending attorney's fees in the multi-millions. And if you're unsuccessful, then you're out of luck.
Thanks, Kevin. I appreciate it. That is all the questions we have today. We've kept Kevin and our audience over. Kevin, thank you so much for joining us today. That was really informative. And I know that our online audience and in-person audience really enjoyed that and gained a lot of information from it.